thank you everybody for joining us. My name is Jie Huang. I am an immigration attorney at Scott Legal PC. So today we are going to spend some time looking at the L-1 visa requirements and answer the top questions that come up when preparing an L-1 visa application. So just a few things before we get started today. Scott Legal is a full-service immigration law firm. We assist individuals pursuing various types of visas, including family-based and employment-based visas and immigration options. Our main specialty is assisting entrepreneurs and investors. So we regularly process a high number of E2 visas, for example, and L1 visas also. We will be continuing these webinar series, and we will be doing at least 2 webinars a month on different immigration law topics. So please feel free to follow us. At the end of this webinar, we will be sending out a few things. First, we will send you all a PowerPoint that will be used in this webinar, so you can refer to it in the future. We will also be sending you a comprehensive L1 visa guide that has a lot of useful information you can refer to as well. We will send you a link to where you can sign up for additional webinars in the future. And we will send you a link to this webinar as well, as it will be recorded. Finally, this webinar will be available on YouTube, and we encourage you to subscribe to our YouTube channel as we regularly upload immigration law related videos. And we will also send you a link where you can follow to set up a consultation with one of our attorneys. So today we are very lucky to have Kelly Legrand-Wiener, who is the managing attorney at the firm with a wealth of L1 visa experience, who will be presenting about the requirements and considerations in applying for an L1 visa. Finally, for any questions you may have, please feel free to add them to the chat box or the Q&A function, and we will try and get to all questions. So without further delay, I will turn it over to Kelly.
Thank you, GA. Perfect. So today we're going to talk about really the L1 visa requirements. We'll talk about the basic L1 visa requirements, some new office requirements, and some other approaches to L1 petitions. So let's get started just talking about how do you qualify for an L1 visa. So the L1 visa is basically what they call an intra-company transferee visa. And what that means is it allows U.S. companies to transfer an employee from abroad to the United States. In order to be able to be transferred to the United States, first you have to decide, is there a qualifying relationship between the U.S. company and the company abroad? So a qualifying relationship for the L1 is going to be either a parent, an affiliate, a branch, or a subsidiary. So let's say, for example, that there's a company, in the UK, and they own 100% of a company in the United States. So that would be, a parent-subsidiary relationship, and that would work for the L1. So you always have to first look at that corporate relationship between the two companies. Another requirement is that both of these companies need to be doing business. So that is defined as the regular, systematic, and continuous provision of goods and services by a qualifying organization. So what they're trying to avoid here is literally, just having, for example, a company that you've incorporated in the United States, but that has no activity. That's generally not going to qualify for an L unless the plan is for this employee to start what we call a new office. And we'll talk a little bit about the special new office requirements in the next slide. So both companies need to be doing business. So this is something where, companies need to be able to provide things like tax returns, invoices, payroll lists, just proof that they're an active ongoing enterprise. So the next thing we need to look at is the actual employee applicant. And has this applicant worked for, the foreign company for at least 1 year? And this has to be one continuous full-time year out of the past 3 years. And the second thing we look at with the employee applicant is, did they work in a managerial, executive, or specialized knowledge position? So you can't just transfer any employee. The employee needs to fit into one of these categories, needs to have been working for at least 1 year out of the past 3 years in one of these categories. And they need to be going to the United States to hold an executive, managerial, or specialized knowledge role. Something to keep in mind is the roles do not have to be the same. So it is very common, for example, that you would transfer for, a manager and they're going to then be a manager in the United States. That being said, there's also circumstances that arise where somebody is being transferred. Perhaps they were a manager abroad and now they're being transferred. They're being promoted to an executive role. So that's something else that can happen. So that is also allowed. You just need to be able to show how the employee applicant is qualified for this role in the United States if the role is going to change. A few important things to keep in mind about the difference between an L-1A and an L-1B visa. One is that for an L-1A, this refers to our executive and managerial employee applicants. So if somebody is coming to the United States to hold a managerial or executive role, they'll be applying for what we call an L-1A visa. An L-1A is sometimes considered more favorable than an L-1B just because you can get a little bit more time. So you can get up to 7 years on an L-1A visa before you either need to depart for a year, find another visa category available to you, or perhaps transition to a green card if you want to stay in the United States permanently. So for the L-1B, those are for employee applicants whose U.S. roles will be in the specialized knowledge category. And these you can renew for up to 5 years. That's kind of the main difference between the L-1A and the L-1B. So let's talk now about some new office requirements. So, as mentioned in the prior slide, both companies, the U.S. company and the company abroad, need to be actively doing business. However, a company abroad can send an L-1 employee to open up a new office in the United States. And a new office is defined as an organization which has been doing business in the U.S. for less than 1 year. So even if let's say you've incorporated a company a couple years ago, but it's just been completely inactive, you haven't done anything with that company, and then you just started trading this year, and it's been a couple months that you started trading. So that the timeline for whether it's going to be a new office, you're going to look at the time for when you actively started trading, as opposed to the date of incorporation. If you are sending an employee to open a new office, there are some additional requirements that you have to meet for the L-1, some special things to know. So for an L-1A new office petition, first you have to show proof that the company has secured sufficient physical premises to house the new office. I think this is particularly important to highlight in light of, obviously there's been a huge shift towards, remote work, virtual offices. People are very often asking about that. Unfortunately, the regulations do not keep up with the times in that way. And so this is specifically written into the regulation, whereas with some visas, for example, like the E2, perhaps there's a bit more flexibility now in remote work. For the L-1A, for a new office, there really is not flexibility. To meet this regulatory requirement, you have to have physical premises to house your office. And so, for example, what they might expect to see is if your business plan shows you're going to hire, 6 employees in year 1, then you need to have office space that will support those 6 employees. Sometimes people might try to use co-working arrangements and argue, well, I'm able to add new office space, as needed. And I'd say that, while that's certainly one approach you can take, generally, USCIS is not very favorable towards co-working spaces. It does, greatly increase your likelihood of a request for evidence. There are arguments you can make, but it generally will strengthen the case if you're able to get commercial office space that's just going to support the number of employees you plan to hire in year 1. Another thing for L-1A new office petitions, so if you're going to be an executive or manager coming to open a new office, then you have to have been an executive or manager abroad. So that's a bit different. With a normal L-1A petition, your position abroad could be a specialized knowledge worker, and you're coming as an executive or manager now. But for a new office, you have to have actually been an executive or manager for 1 year prior to coming to the United States. And the job you are going to hold needs to be a managerial or executive job, and you need to have that authority over this new operation. Another thing you need to be able to do is show that the intended US operation is going to support an executive or managerial position within 1 year. And the way that you do this is you essentially will provide some additional documentation, perhaps a company memo that outlines kind of the scope of the office that you're opening in the United States. What is your planned organizational structure over the years? What are your financial goals? How much investment is being made into the United States to actually open up this office? Does the foreign company have the ability to pay this employee and start up this business in the United States? And then you also need to show the organizational structure of the foreign company. So really what they're looking for here is, if you're sending an executive to the United States and you're saying, well, we're going to start up this, service-based company, this executive is going to make $100,000 in year one. They want to see that the foreign company has the ability to actually support that, in the United States. So you want to provide, for example, bank statements, audited financial statements, anything that shows that the foreign company is really in a position to open up this new office in the United States and to capitalize it and make sure that it can kind of get itself off the ground and running. And that's where a business plan is going to be really key for these new office petitions, to show that the new office really will have the ability to sustain itself and to hire enough workers to really support that executive or managerial position. So we generally will recommend, depending on what type of company you're setting up, like let's say it's more of a service-based company as opposed to very labor intensive, maybe 5 or 6 employees at the end of year one is going to be sufficient, because then you can show that you have an administrator, you have salespeople, you have operations people, because the key is you need those employees to show that the executive or manager is going to primarily focus on executive or managerial duties. And we'll talk a bit in the next slide about what is encompassed in an executive and manager, because it is very specific. There's a regulatory definition and the government is very strict about that regulatory definition. So just calling yourself a CEO, just calling yourself a vice president is not going to be enough. That really has to be backed up with specific evidence about exactly what you're doing in the United States. If you are coming as a specialized knowledge worker to open up a new office, similarly to the L-1A, you have to show proof that the company has secured sufficient physical premises. And then you have to demonstrate that the company abroad has the ability to pay the employee's salary and commence doing business in the United States. So a little bit less of extra documents are needed for the L-1B, but very similar documents are needed, I think, for both. So let's talk a little bit now about who qualifies as an executive and, or a manager. One, I think, important point to make is that you do not want to argue for both. So as you'll see here, there's very specific regulatory definitions for each one, making the argument to USCIS, well, they're an executive or a manager, or executive and manager, is really not something that you want to do. This is not a successful strategy. And often will, result in USCIS issuing a request for evidence and asking either that you clarify which one you're applying for, or that you show you meet both of these criteria, which can be quite difficult to do. So let's talk a little bit first about the executive. So an executive directs the management of an organization or a major component or function of the organization, establishes goals and policies, exercises wide latitude and discretionary decision-making, and receives only general supervision or direction from higher level executives or a board of director or stockholders. So when you are deciding, should I apply for an executive or a manager, it is a good idea. Think, okay, what is my title? Is it a C-level title? Is it something that is arguably at the very, very top of that organizational chart? What is my specific responsibility? Do I direct, when you say direct the management, do I have managers working underneath me? Am I directing, a huge component of this organization? Usually, for example, if somebody's either the business owner or they're the CEO, it can be a very clear category. But it, depending on kind of how many organizational tiers your company has, it can also be a question mark. However, generally, if when you're looking at the tiers of organization within your company, if you're not kind of in the first 2 tiers, probably you're not looking at that executive authority. So let's move to manager. I think that manager, this is somebody who manages an organization, department, subdivision, function, or component of the organization, supervises and controls the work of other supervisory, professional, or managerial employees, or manages an essential function, has authority to hire and fire and recommend other personnel actions, functions at a senior level within the company, and exercises day-to-day discretion over operations. So something to keep in mind here is that somebody that is just a first line manager is likely not going to qualify. It is really important that you're able to show in that organizational chart that that an L-1 manager is managing other managers or other professionals, right? So let's say you're the finance manager managing the entire finance department. Perhaps you only have people under you that are not managers. That's okay. Let's say you're managing 7 CPAs who are all working on different types of the, finance and accounting functions for the company. That would likely be fine, from the perspective of proving that you supervise the work of other professional employees. So that's just a good thing to keep in mind, that not every manager will qualify. Similar to the executive, just because you have the title manager, in your job title does not necessarily mean you qualify. You really have to look at the specific definitions and say, okay, do I actually do this? Do I have this authority to hire and fire the people within my department? Another thing to consider for managers is what we call a function manager. So kind of embedded within these definitions is manages the organization or a function, supervises and controls the work of supervisory, professional, or managerial employees, or manages an essential function. So managing a function can kind of be a way that perhaps if you are actually very, let's say you're managing an important function within the company, but you don't have that many people actually working under you or for you, that can be potentially something to consider, as long as you're able to show that you actually manage this particular function. Again, going back to our example of perhaps a finance manager, perhaps you don't have, 7 CPAs working under you, but perhaps you only have 2 CPAs working under with you, but you coordinate with other legal, accounting, accounts payable, other people within the organization to manage the finance function. That's something also that can be considered if you are an applicant that does not have, a large number of people working under you, or you don't feel like you would qualify as a personnel manager. So always also something to keep in mind. You do have to meet some extra requirements, so it can be, more complex than qualifying as a personnel manager, but maybe a good option. So let's move a bit to specialized knowledge. So specialized knowledge is for L-1B applicants. This means special knowledge possessed by an individual of the petitioning organization's product, service, research, equipment, techniques, management, or other interests, and its application in international markets, or an advanced level of knowledge or expertise in the organization's processes and procedures. So in either case, it's good to be able to show that this particular knowledge is not commonly held throughout the industry. I think a key point here is they really want to know, why couldn't you hire someone in the US that has this particular knowledge? There's lots of kind of different memos that have come out over the years from US Citizenship and Immigration Services, trying to kind of clarify, what will qualify for the L-1B, because it's really a category that's received a lot of scrutiny. I think that, some, certain things to keep in mind that can be helpful. Let's say that you have an employee who's somewhat new to the field, like hasn't been working in the field for 15 or 20 years, but started with your company when your company was first getting started up and was really instrumental in developing your policies and procedures, became someone who was just really knowledgeable about how all the teams integrated and worked together. Sometimes that can be a strategy that's successful for someone that you want to transfer who may not have all those years of experience or proprietary, knowledge of a particular product, but has been with your company long enough to show that they have advanced knowledge of your particular company's processes and procedures. So that's another thing to keep in mind, potential strategy for specialized knowledge. So let's talk a little bit about what documents have to be submitted for an L-1 petition. So one thing that has to be submitted, corporate documents showing that qualifying relationship between companies. So proving that there's a parent, subsidiary, affiliate, or branch relationship. Generally, you're going to show the corporate formation documents for each company. And then depending on what form those companies have, corporate resolutions, shareholder ledgers, meetings, minutes of board meetings, anything like that that's going to demonstrate what the current ownership is of the companies. Company tax returns, that show the ownership structure are also, can be used for this particular requirement. Then you need to show that each company is doing business. So these are things like company tax returns, audited financial statements, commercial lease agreements, invoices from clients, payroll summaries, organizational charts showing the employees working within the company. Now we move away from the companies and we move to the employee. So for the employee, first you need to show proof that the employee has worked for the company abroad for one continuous year out of the past 3 years in a managerial, executive, or specialized knowledge role. So, for the first part, showing the length of time they've been working, generally pay stubs are going to be, the most effective. Sometimes if somebody's an owner of a company, perhaps they don't, they're not an employee on payroll, then we would potentially show distributions, that have been taken, or issued based on work actually done for the company. I think something to keep in mind is just because you are an owner of the company, you don't absolutely qualify unless you have to actually have been working for that company abroad. You can't just be a passive owner and still qualify for the L-1. When we're looking at proving that you worked in a managerial, executive, or specialized knowledge role, you're going to need to include things such as personnel records, any training records from HR, a detailed job description signed off on by someone with authority to sign for the company abroad, organizational charts that show the company hierarchy specifically within your department. Often you're going to want to show, job duties of your subordinates, perhaps what degrees are required for those subordinates, what salary, they make, and then anyone that they are actually supervising. Then you need to turn to the role in the United States. So here's where you need to prove that the role in the United States is going to qualify as managerial, executive, or specialized knowledge. You're going to submit similar types of documents. So a detailed job description, organizational chart showing the employee hierarchy. If there's were any internal company documents discussing the transfer or why this particular person was needed, that we're going to, because of their specialized skills, because you need an executive or manager on the ground, all of that can also be very helpful to demonstrate that you meet this requirement. So let's talk a little bit about requests for evidence. For the L-1, requests for evidence are unfortunately extremely common. Recent USCIS data, as shown here, shows that in 2019, 2020, and 2021, over 50% of L-1 petitions received requests for evidence. So they don't break down the data between L-1As and L-1Bs. And L-1Bs can often be very heavily scrutinized because sometimes extremely large technology companies are transferring a huge number of L-1Bs. So sometimes that drives up the request for evidence statistics. However, that being said, RFEs, even for individual L petitions, are very common. Most of these RFEs are going to challenge whether the applicant meets that definition of manager, executive, or specialized knowledge worker. So even though sometimes I think companies can be quite surprised with the level of detail and the level of description that you have to get into about each job, that really is what USCIS is requiring. They do require a very specific look, into what the person is actually doing and checking off those boxes of, does this meet the regulatory criteria, or is this person doing something that's outside of that? And if it's outside of that and they think that it's, a high enough percentage of the job duties, then they can deny on that piece. If you're responding to a request for evidence, you want to go back and provide even more detailed support letters. So oftentimes in the request for evidence, they'll write out, actually in the request and say, here's what you said, we find this too vague, we find this too general. So sometimes you need to go back and almost provide specific examples of what the person is going to do. So if you say, draft policies, that's really not going to be enough. You would have to, actually outline, for example, we'll be responsible for drafting, all policies that will guide, company processes over X, Y, and Z time, including, and then provide as much detail as you can. Similarly, with support letters and charts that you're providing about the employee hierarchy, about the job, you really want to support those as much as possible with objective evidence. So that means oftentimes work product. It can be easier to do that for the work they've done abroad. You can show, okay, here's, a policy guideline they drafted. Here's, contracts that they signed that are for, very important things within the company. Here's a manual that shows they're the senior executive that's, being given all signing authority for the company. Those types of things I think are extremely important, because otherwise they're really just looking at documentation, letters that you've produced, and they don't want to take your word for it. They want to see that embedded within the company, there's already been, evidence that the person meets this criteria. Perfect. So let's talk a little bit about, timing and dependents who can come with you to the United States. So in terms of timing, the L-1 petition first has to be approved by USCIS before you can go to the consulate and get a visa stamp. Processing times vary, but generally are several months for a petition that was filed without premium processing. There is an option to pay an additional $2,500 for premium processing. You'll get a response within 15 calendar days. This can be an approval, a denial, or a request for evidence. After the L-1 petition is approved by USCIS, then the employee applicant can prepare the DS-160 application and schedule an appointment at a US consulate to get the L-1 visa stamp. So that's, generally when you're going to that, that interview, they shouldn't be reassessing the petition for underlying eligibility. However, they are interviewing you to make sure that it seems that all the information that was laid out in the USCIS petition is credibly reflected back to them by the specifics of your interview. So that means you want to prepare with your immigration attorney ahead of time. You want to make sure that you've talked through, what was the specifics of your job abroad, what's the specifics of the job you'll be doing in the United States. You want to talk with the immigration attorney about whether there's any prior visa denials or overstays or anything that could, potentially flag you for inadmissibility at the visa stamp stage of the process. However, if all those things have gone through, then, generally, as long as you're able to present that evidence to them and confirm for them, that you're holding, a job that qualifies, they should be able to stamp the visa. If you're already in the United States, let's say perhaps you come on a B visa and you've been here for a little bit. Sometimes, this might happen when there's really long delays at the consulate. Maybe someone has come, just to do some initial business meetings that are permitted on a B1 visa, to kind of get to know their new team. Sometimes you can then potentially do what we call a change of status to L1. I'd say that's a bit more rare for the L1 just because you have to have had that year abroad. So usually you are working abroad already. However, if you are in the US in a valid status, unfortunately, this doesn't include ESTA, you can change your status to L1, so you're not having to immediately, go to the consulate. In terms of dependents, spouses and unmarried children under 21 can accompany you on L2 dependent visas. The spouse is able to work and children are able to attend school, although they are not allowed to work. There was also a really favorable change for spouses in the recent past, where L2 spouses used to have to apply for work authorization. Now they no longer have to do that. They are just authorized to work incident to their status. So what that means is when you enter on your L2 visa, you want to make sure they've given you an I-94 in what we call L2S. So that's L2 spouse. And as long as you have that, that can serve as, as proof of your work authorization. That allows you to get a social security number. And you can go ahead and start working without having to wait months and months or file a work authorization application with USCIS. All right, so I think, a common question we get is, does an L1 lead to a green card? I think a really, really great thing about the L-1 is that it's what we call a dual intent visa. So what that means is that when you have an L-1, if you have a green card petition pending, you can travel freely. You don't have to worry about reaching any point in the green card process where you start to get questioned at the border about what your intent is. So for example, if you're on an F1 student visa or you're on a TN, work visa, those are visas that have a really high standard for proving that you don't intend to immigrate. To qualify for those visas, you have to show you have a residence abroad that you don't intend to abandon. That is not the case for the L-1. So this is oftentimes viewed as a very favorable visa category for people that want to become a green card holder, because you do have that flexibility. You can have this temporary visa and you can also have the intent to immigrate. And that's fine. There's never a point where you really have to worry that you're going to get questioned at the border or stay in the United States without being able to travel, on the L-1. So that being said, the L-1, just getting an L-1 does not mean that you are now 100% locked for a green card. I think that's another misconception that can kind of happen is, okay, I have an H-1B or I have an L-1, so now that means I'm on the path to a green card. That's not necessarily the case. As with all other types of visas, if a green card category is available to you while you are on this L-1, you can apply for it. That does not mean that you 100% are going to qualify for a green card just because you obtained an L-1 visa. So let's talk about some of the options for L-1s. So one green card option for L-1A managers or executives is the EB-1C. This is known as the multinational manager or executive green card. It's very similar to an L-1A in its requirements, as listed here below. You can see the requirements are very similar. However, there is a heightened standard. So just because you've qualified for an L-1A does not mean you will qualify for an EB-1C. I think very similar, sometimes people will get an O1, extraordinary ability visa, and they think they'll automatically be able to get an EB-1A, extraordinary ability green card. Very big difference in standard between the O1 and the EB-1A. Similarly, big difference in standards between the L-1A and the EB-1C. So some of the, requirements are similar, like having a qualifying relationship between the company abroad and the U.S. company, having both companies be doing business, showing that the employee has been, working abroad, for the requisite period of time, and the benefit of the EB-1C is you don't have to undergo a labor certification. And we'll talk a little bit about labor certification in a minute, but as you'll hear, the labor certification is very long, can be a very onerous process. So if the EB-1C, if you are in an L-1A, I think it's always good to assess whether the EB-1C will work before moving to the labor certification process, because it does allow you to skip it. That being said, again, sometimes people will get the L-1A and the first day they arrive in the US on the L-1A, they want to immediately file an EB-1C. Generally you want to think about what is the scope of operations in the United States? What was the scope of operations abroad? Because when you go for that EB-1C, they're going to re-examine that, and they may, perhaps maybe in your adjudication, they didn't focus so much on the company abroad or how large it was. But when they go to the EB-1C, they may look at that and say, well, it was a pretty small company abroad. Like, did you really qualify as a manager? Did you really qualify as an executive? So you're not going to get, 100% deference to what they decided on the L-1A. They're going to look at it differently. That being said, if it is available to you, if the scope of both operations are large, if the corporate relationship exists, both companies are doing business, your job squarely falls into these categories, it can be a really great option. The way that you do it is that you file what's called an I-140. And if a green card category is available to you, you can also simultaneously file an I-485, and that will adjust your status within the United States. There was also an exciting change recently for EB-1Cs where premium processing, which had not been available, is now available. So what that's going to look like is starting January 30th, people applying for EB-1Cs can file Form I-907, pay an additional $2,500, and USCIS will adjudicate the petition within 45 days of when they've decided they have a complete petition. So that does give us, we'll see how it works in practice. What that means is you may get a response from USCIS that says, well, we didn't have all of the proper documents to do an adjudication, so they might buy themselves some more time there. That being said, if they decide they do have all of the documents to start the 45-day clock, you'll get a response within that time, and that would be an approval, denial, or request for evidence or notice of intent to deny. If it's a request for evidence or notice of intent to deny, then you'll submit a response, and then you'll get an answer within 45 days after you submit your response. So, still a period of months kind of before you're going to find out. However, much better than it was. It was previously, several months, even over a year, without any ability to, to speed up that timeline. So I think a really exciting change, for EB1C. So let's move to, if you're on an L-1B, what are your green card options? And for either of these, there may be other options that are available within the investment sphere, within the sphere of family, if you have family members. So we're talking here just about some, some employer-based options and kind of the most common options that we see that come up for our L1 clients. So let's look at the L1B. L1B is, people on specialized knowledge. And for those people, generally the process that they're going to undergo is called the PERM process. So this is the labor certification process. This is where the company must test the labor market to see if there's any willing, qualified, and available U.S. workers. If there are not any willing, qualified, and available U.S. workers, they put out advertisements. They interview people, they don't find anybody, then they're able to file a labor certification with the Department of Labor. If that gets certified, then you can file the I-140. So, when we look at these two together, the EB1C versus the PERM process, the benefit you get with the EB1C is you skip that whole first process of testing the labor market and you just file the I-140. If you're going to do the L-1B, things to keep in mind, you want to make sure that you're talking with your employer about your plans because you only have 5 years. And as it stands right now, with all the different delays in the Department of Labor processing times for PERMs, it can take 3.5 to almost 4 years to end to have that green card in your hand. So that's just something you want to keep in mind. If a green card is something that you are interested in, you want to be talking with your U.S. employer to see what are their plans. Are they willing to sponsor you for that green card? And if they are, you want to work together with them to make sure that you're not going to run out of time on your L-1B, before that green card is granted. All right, so we've reached the end. I'm not sure if we have any questions that have come in.
Yeah. Thank you so much, Kelly. So we have just one question in the question and answer, and it was really related to what you just went over, which is the green card options for L-1B. And so you already went over how long would be the process, which was 3.5 to 4 years to get the green card. But does the applicant have to stay with the same company during the whole process?
Right. So really important question. I think so, basically for most of the process, the answer is yes, in the sense that if you try to switch to another company, you would need a different visa option because just having a green card, like having the PERM having been filed, the I-140 having been filed, none of those actually give you any status in the United States. However, if you've gotten to the stage where your I-485, your green card application has actually been filed and it's been pending for at least 180 days, then you become eligible for something called portability. And that's where you can basically port to either another employer or even to self-employment, as long as you're porting to the same or a similar occupational classification. So let's say you're here as a software developer, you've been here, your petition is filed, it's been pending for over 180 days, you get a new job offer in a similar occupation. When you look at the job duties, when you look at the salary, when you look at the, the codes, the ONET codes, that are put out by the Department of Labor, those look similar. Then yes, there's a potential opportunity for you to leave that company and essentially port to this new job. You do have to file something called an I-485 Supplement J with USCIS. And if they reject it, the whole petition is denied. So it's not like you can just switch back immediately to your old employer easily if they're rejecting the old one, or the new one. But so there is some flexibility towards that end of the process. But unfortunately, if let's say you're in the middle of your perm, your company has tested the labor market and you want to jump to a new company, if you have a visa option available to you that allows you to do that, you certainly can. But that would be a completely separate process. You would basically lose anything that had been done on your green card so far. So I think an important question, especially because of how long it can take to get the green card.
Yeah, definitely. Thank you so much, Kelly. I don't think we have any other questions from the audience. So yeah, I really hope that this session has been helpful for everyone. It certainly has been helpful to me. Yeah, feel free to check out the resources that we will be sending you. And I hope everyone has a great day.
Thank you. Have a great day.